listening to the retirement architect, David Reyes.
So we want to welcome today a very special guest and good friend of mine. And we're very fortunate to have a great trust and estates and business attorney, Brenda Geiger. I know that, Brenda, you graduated from University of San Diego. You had a bachelor's in psychology, if I'm correct, and then you got your JD, your law degree from USD as well, correct?
Yes.
I think you were editor on the International Law Journal. That's what I'm reading here. Is that correct?
I was an editor on the journal and published a law review article there.
Brenda, the reason we're having you on today is I find when I sit down with clients, Brenda, that they just don't really have a very good understanding of just basically how trusts work in a lot of ways. And then we're going to get into some more advanced topics on how to, asset protection issues with trusts, and also some new IRA laws that have just passed for beneficiaries of IRAs, and how to protect those IRAs. So let's just start from the beginning. So Brenda, tell me, if you could give the number one basic advice, that you see, or basic things you see that are problems with existing trusts for people right now.
I think the number one thing I see is the distributions to beneficiaries are set up in a way where they're either going outright to the beneficiary or they're going out at a certain age. So common to see would be at the age of 25, my son or daughter gets 50% of their trust. At the age of 30, they get the full balance of the trust. And the problem with that is there's no creditor protection for that money that they've left to their kids. So if they get divorced, if they have a bankruptcy, if they have a creditor problem, they have a lawsuit waged against them, they have a business that they start up and fails, that money that their parents have left to them now is at risk because they have what's called a demand right in the trust. They can demand that money from the trust. So that's one of probably the biggest problems I see. But there are a lot of other things too.
You think it's the tax side of it, or is it a combination of the tax and the asset protection side?
Well, the tax side, so what we could do to fix that, because there is no tax implication to fix it, we can have it held in a continuing trust that the son or daughter controls, and then if they do run into one of those problems, they simply resign as the trustee, and then they appoint somebody who's a third-party trustee, like a private fiduciary, a bank. It could even be their best friend, their attorney. It could be, a CPA. So there's a whole litany of people that they can put in charge. So there's no negative consequence to that.
Expand more when you say that the age differences. So I know that most trusts that I read and that we refer you over to, they're going to have a specific age, and that's basically it, right? They reach 25, 35, like you're saying. So what again, reiterate, what is the major issue with that specifically?
Well, if, let's say, they now inherit the money and their age of distribution is 30 and they inherit at 28, or really any age at that point, and if they're being sued or they're going through a divorce or there's some problem that happens later, then that creditor can pierce right through and get that money, even if the child has still left it in trust. They just decided to keep it in that wrapper. If they've got that demand right against the trustee, then a creditor can step into their shoes and say, you know what, I want that money. And the judge is going to say, okay, there's a demand right here. They have full access to it, unfettered access to it, so you can have it too.
So, yeah, in 99.9% of all trusts that I see that are written, that's how they're written. So what do you do specifically to protect the beneficiaries of these parents for their children or grandchildren, however it may be, to deal with that creditor protection issue that is a big problem?
Well, I'd say most of the time we end up restating their trust, which is called like a super amendment. So it's just you can still keep the original title of the trust. So if there's anything that has been transferred to the trust, we don't have to go through that funding process to take it from one trust to a new trust. It's really the same trust. We're just canceling out the old words and putting in new. And the primary reason for that is not just because I have to update how the distributions go to the beneficiaries, but there's often a lot of other problems with them. For instance, there may be no consideration to what if a beneficiary later on becomes a special needs beneficiary. We typically will draft into our trust special needs standby provisions so that if somebody did, the trustee could convert their trust into a special needs trust. So, even if it's unlikely to happen, nobody knows in the future what's going to happen to my son or daughter, or even a grandchild for that matter. So it's just best to have that as a standby. And then there are often other problems, too. Sometimes there's no way to effectively appoint a new trustee if there's been a vacancy. Sometimes who the trustee could be an issue, depending on the type of subtrust that's drafted. Trying to think of some other common things that I see. Sometimes it has to do with the way it's structured for the husband and wife. If it's a married couple, sometimes they don't have any creditor protection for the spouse, or they're not adequately protecting against estate taxes if it's a larger estate. It's much easier to do that kind of planning inside the revocable trust than to rely on portability laws, which we now have, where we can port somebody's exemption onto a surviving spouse's return.
The main issue, here is what you're saying, and what I see, and the main reason I refer clients to you is that typically, I see the trusts are, outdated, or they don't have the proper provisions. But most importantly, what you're saying is that the bottom line is that their beneficiaries are exposed to external creditors for certain types of litigation or lawsuits or bankruptcy, those types of issues. Is that a fair statement?
Yeah, I think the only thing I'd add is the thing I think most of my clients are worried about is what if my son or daughter gets married and then later gets divorced? Is what I left to them going to be going to that spouse that they're divorcing from?
And I guess I'm lumping that into there, but that's an important point, saying that basically, yeah, if there's a divorce and there's commingled assets, in the state of California specifically, then the fact is those assets can become part of somebody that was an unintended beneficiary, right? So, I think in general, everyone out there who's listening, you need to have a review, and Brenda will review this for you complimentary as being part of our show. And I know she normally charges almost $1,000 just to do this. And so if you want to take advantage of just her reviewing your trust or looking at your estate in particular, if you don't have a trust, just give us a call at 1-800-611-1967. That's 1-800-611-1967. And Brenda, what is your web address so they can have your website address?
It's geigerlawoffice.net.
Okay, geigerlawoffice.net. And I know you've written many books. You're on book number, how many? 4? I know you're right.
We just sent the 5th one off to the publisher.
Tell me about your latest book.
Well, the latest one is called Retirement Protector Trust, and it has to do with a new case that just came out in the U.S. Supreme Court, and it was a unanimous decision that basically said if you inherit an IRA, that is not an exempt asset in the bankruptcy court from your bankruptcy creditors. But we've been doing Retirement Protector Trust for years to protect assets from those same types of creditors, bankruptcy lawsuits, divorcing spouse, all that stuff. We've been doing that to protect those types of assets for years in the specialty trust. But this court case just kind of brought light to the whole thing for the mass media to pick up on.
So give me an example of where this situation would apply, that with this new law would apply and would be a problem for an heir or beneficiary of an IRA.
Well, I can tell you just like briefly the person that was subject to this case. It was a woman that inherited about $450,000 from her mother, probably about 10 years ago, and she decided to exercise her to stretch the IRA, which means that she can take small chunks of it based on her age. There's a single life table in the IRS code that you look at. You just look at your age and say, okay, the divisor is 26.2. I'm just making something up here, but just as an example, you divide that into the account balance by December 31st in the year after the original owner died, and that's the amount that you have to take out. That's your required minimum distribution. But the principal remains intact inside the IRA, and continue to grow in that tax-deferred environment, which is a huge benefit because if you stretch it out over life expectancy, it's a lot more than usually what they would have taken out, because all the taxes that apply, because you're going to have to pay ordinary income tax on that in the year of distribution. So she decided to stretch it, and then about 8 years later, she went bankrupt, and she claimed that was an exempt asset, that the creditors didn't have access to it. So basically, the court decided that, no, this is not an exempt asset because it's not a retirement plan as it pertains to you, because there are a few factors that are different than what the original owner had. So one of them was that you cannot continue to contribute to that IRA. The second was that there's no 10% penalty for early withdrawal, and there's unfettered access to the account. Because of those factors, the court unanimously decided that you cannot claim that this is an exempt asset in a bankruptcy. So the analogy is that it's going to be applied to other types of creditors as well. And, the courts in all the states have differing laws, but this is, the U.S. Supreme Court case, and it's going to have a big impact as precedents for all of the state cases as well.
You're here with Brenda Geiger, a state tax and business attorney from USD Law here locally in San Diego. Brenda, can you hang out with us for one more segment here?
Oh, absolutely. I'd like to.
We are speaking with Brenda Geiger, estate planning attorney, business attorney, tax attorney, and we'll be right back with more from Brenda Geiger.